If you're getting this video, it probably means only one thing. We've scheduled your deposition. Now, if you're like most of our clients, you probably have never had your deposition taken before. You're probably nervous and a little concerned about how it's going to go. Trust me, you're going to do great. We prepared this video as a little pre-prep of how your deposition is going to go. In the next couple days, you're going to receive a few items from us, including a deposition checklist, a copy of your interrogatories, and a copy of the chronology of the treatment you've had so far up to this point. You will come and meet with me a couple times before your deposition, so you'll be completely prepped before your deposition takes place. Now, what is a deposition? A deposition is an opportunity for the other side to ask questions of you, to find out what you do and do not know, and what you would and would not say if you were called to testify at trial. A deposition is also an opportunity for the other side to evaluate how you will come across to a judge or jury deciding the case. And it's also for us to look at weaknesses that we may not have noticed in your case as well. And you may remember or say something you haven't already told us, and we're able to look at it a second time as well. Now, there are a couple of things a deposition is not. A deposition is not an opportunity for you to convince anyone, especially the other lawyer who is taking your deposition, about how right you are, how great your claim is, or what a wonderful person or a skilled professional you are. Here are a few deposition basics we prepared. The deposition will take place in either the conference room at our office or in Steve Fleschner's office across the side of the building. Now, who's involved? There are going to be a few people involved in your deposition, including the court reporter. They are present to record everything and to create a transcript of your deposition. The opposing attorney, they are there to ask questions about you and the accident and try to get a feel for what the possible outcome of the case might be if it went to trial. Now, my job is a little odd. My job is to sit there and listen. I can object to questions on technical grounds. However, I cannot object just because the question seems unfair. When the other attorney is done with their questions, I may ask you a series of questions if I feel like some of your questions need clarification or to expand on them if need be. Now, your job is to just answer the questions posed and only the questions posed. Don't imagine that anything you say will win your case. On the other hand, it is very important to understand that something you say may lose your case. If you need to take a break, we can take a break. Let myself or the other attorney know, and we'd be more than happy to take a few minutes to recollect yourself. However, you have to answer the last question asked before you can take a break. The deposition should take about an hour to 2 hours depending on the attorney. Now, there are 3 things to remember in every stage of your case. 1, we must be able to prove fault, meaning someone else is at fault for your accident. 2nd, we have to prove damages that have arisen from the accident. The 3rd thing is they're always trying to evaluate you as a witness. The attorney will write a letter to the insurance company letting them know how they believe you will be as a witness. They take off points if you're a bad witness, are not credible, are not believable. Now, the next few things is what I call the 4 Fleschner rules. The first rule is listen to the question. You are not a mind reader. You do not know how the question will be formulated until you have heard it fully asked. The second thing is be sure you understand the question. Make sure you listen to the question and you understand exactly what is being asked. If you answer in a way that has little or nothing to do with the question, or otherwise is not responsive, you do not understand the question. If you do not know the answer to the question, do not guess, do not speculate, and do not help the lawyer refine the question. If you do not know or remember something, it is perfectly acceptable to say so. Indeed, it is only the correct answer. There is nothing wrong with answering "I don't know" or "I don't remember," provided those are the truthful rather than evasive answers. The third rule is think about the answer. Do not answer a question too quickly. Pause, take a few seconds before you answer the question. And the 4th and final rule, and most important, express the answer in the shortest and clearest manner possible. The more you ramble, the more room there is for confusion, for error, for misunderstanding, and for things that have to be, but may not be able to be, cleared up later. In a deposition, brevity is indeed the soul of wit, and the less said, the better. Period. Over the years, I've compiled a few common problems clients have had at depositions. 1. Don't interrupt. In real life, when we talk, we interrupt each other all the time. If you begin to ask a question and I know what it's going to be, I answer it anyway. In a deposition, you have to wait so there are not two people talking at one time. The tough part for a lot of people is we are used to saying and and shaking our head yes or no. You need to verbally say yes or no and be clear so it can actually be recorded and turned into a transcript. The next problem is trick questions. Clients sometimes have this problem that they think they're being asked trick questions. Don't try to figure out if it's a trick question. The other attorney does depositions all the time, so he or she do not prepare so much for each individual case. That being said, they don't know enough about your case to ask a trick question. You will be more prepared than they are. Don't talk too much. Some people want to spill their guts and make sure they say everything they think is important. If you do that, you will provide information they otherwise wouldn't have gotten and you will stick your foot in your mouth. Keep it brief. There's a little trick I do. If you see me tapping my pen, it means you're talking more than you should be. Take a deep breath and start back over. There's 5 areas of questioning that the attorney likely will ask you about. Number 1 is background, educational, employment, health, marital, prior accidents. Some questions that you might think are not relevant to your case, but it's a way for the other attorney to kind of get a sense of how you will be as a witness at trial. The second is, how did the incident take place? Where were you going? Where had you been? What was the weather like? How fast you were going? What did you see? We will later go over the accident report when you come to my office, but these are a few incidents of facts that need to be gone over that the attorney will deal with in your deposition. What were your injuries? An easy way is to start at your head and work your way down your body. The next area is, what was your treatment? You do not need to know the exact dates, only a sense of flow of the treatment. This includes doctors and other treatment facilities. We will go over chronology when you later come into my office. The most important area of question, and one that will be gone through a lot with both you, myself, and the other attorney, is how it's affected you. This is at work, at home, recreational activities. We will discuss this in detail once you come into my office. Finally, if the other attorney asks if you prepared for the deposition, the answer is yes. You met with me, you looked at the police report, your interrogatories. It's okay that you're prepared. Some people are afraid that they will get into trouble for preparing, but it's perfectly fine. When you come into my office, we're going to go through your file in its entirety. It might be boring, but it'll be helpful. We'll go through the police report, we'll go through your interrogatories, and we'll also go through your demand if a demand has been prepared. Now, as I said, this may seem boring, but it's the only way to make sure you're fully prepared for your deposition. As I said earlier, don't think anything you can say is going to win your case. However, there are things you can do that will damage your case. But don't worry, I'm here to ensure that that won't happen. I'll be with you every step of the way, and we'll make sure that you get through this safe and sound.